We're on the record in State versus Daniel Mason, 10 DT 5. Show present the state by Assistant State's Attorneys Earlywine and Jones. Counsel, good morning.
Good morning, Your Honor.
And show present the defendant in person and by counsel Michael Costello. Mr. Mason, good morning. Mr. Costello, good morning. Ladies and gentlemen of the jury, we have completed jury selection, and you have been chosen as jurors in this case. And it's my opportunity now, prior to opening statements of counsel, to advise you as to some basic principles of the law that you will follow in your deliberations as jurors. You really need three things prior to your deliberations beginning. Those are the evidence in this case, the instructions of law that I will give you at the close of evidence, and the closing arguments of the counsel. I would ask you and caution you not to begin your deliberations until you have those three things. The defendant in this case is charged with 2 counts, and he's charged by information, and I will read those counts to you. It is alleged that Mr. Mason, on or about the 20th day of August in the county of Cook, state of Illinois, committed the offense of driving under the influence of alcohol, in that he drove a Hyundai Elantra on Blackhawk Street while under the influence of alcohol. Count 2 alleges that on the 20th day of August, the defendant, Daniel Mason, committed the offense of driving under the influence of alcohol, in that he drove a Hyundai Elantra on Blackhawk Street with an alcohol concentration of 0.08 or greater. The defendant, as you know, has pleaded not guilty to both of those charges. It's important to note that the informations that I read to you are not evidence against the defendant, and nor should you infer any presumption of guilt from them. They are mere formal charging instruments to begin the process that we are engaged in today. It is also very important for you to know that the defendant is presumed innocent of the charges against him, and that presumption remains with him at every stage of the trial and during your deliberations on a verdict, and is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and that burden remains on the state throughout this case. The defendant is not required to prove his innocence and is not required to present any evidence on his behalf. He may, however, choose to do so. You are the judges of the facts in this case, and it is you and you alone who will determine what witnesses to believe and how much weight to give their testimony. Part of my job is to tell you what evidence you may properly hear and consider. After you have heard all the evidence in this case and the arguments of the lawyers in this case, and have received the instructions of law that I will give you, then and only then are you to begin your deliberations. If you become convinced during your deliberations beyond a reasonable doubt from the evidence in this case that the defendant is guilty as charged, then it will be your duty to find him guilty. If, on the other hand, after hearing the evidence, you are not convinced beyond a reasonable doubt of the defendant's guilt, it will be your obligation to find him not guilty. It is essential that you have not arrived at any decisions or conclusions until you have heard in full the three things that I have mentioned to you: all the evidence in the case, the arguments of counsel, and the instructions of law. We are now at a position in the trial to hear what is known as opening statements. An opening statement is not evidence and should not be considered by you as evidence. It is a statement by a lawyer about what he or she expects the evidence to show. Any statement made by an attorney in opening statement that is not supported by the evidence should be disregarded.